Hello viewers, I am Dr. Simranjeet Kaur, Professor and Principal School of Law, City University, Ludhiana. Today we will discuss HLA Hart, Concept of Law, Postscript. HLA Hart, the concept of law in the year 1961, stand as the cornerstone of the modern legal philosophy with its postscript representing a crucial refinement and defense of his legal positivist theory. The postscript, published posthumously in 1994, addresses significant criticism of Hart's original work, particularly those raised by the Ronald Dworkin, and provides essential clarification of his position on the legal positivism, the relationship between the law and morality, and judicial discretion. This analysis explored Hart's response to his critiques and his development of soft positivism, offering valuable insight into the ongoing debate about the nature of the law and the legal system. After going through the video, students should be able to understand the key component of Hart's soft positivism and its distinction from the traditional legal positivism. Analyzes the debate between the Hart and Dworkin regarding the role of interpretation in law. Evaluate Hart's response to criticism about the relationship between law and morality. Comprehend the concept of judicial discretion as presented in Hart's theory. Compare and contrast Hart's practice theory of rules with competing theoretical frameworks upon completions. Student will be able to articulate the main feature of Hart's refined positivist theory. Critical assess the relationship between the rules and the principles in the legal system. Explain the role of the rule of recognition in Hart's theory. Evaluate the debate between Hart and Dworkin on legal interpretation. Apply Hart's concept to the contemporary legal issues. Analyze the relationship between the law and the morality from both positivist and interpretive perspective. So let's start with the introduction. The concept of law is in 1961 book by the legal philosopher Herbert Lionel Adolphus Hart, in a short HLA Hart. In the book, Hart initiates his theory of the legal positivism, the view that laws are a duality of the rules made by the humans and that there is no inherent or necessary connection between law and morality. Hart sought to provide a theory of descriptive sociology and analytical jurisprudence. He deals with some traditional jurisprudential topics such as the nature of law, where the laws are the rules, and the relations between law and morality. In chapter 1 of his book, he lays open the question, what is the connection with law, caution, and morality? Is law about rules exhaustively? Hart answers these by placing law into the social context with the aid of linguistic philosophy inspired by Professor Granville Williams with an analysis of the legal terms. According to Simpson, A. W. Berrien, Reflection on the Concept of Law, Hart's book has remained one of the most influential texts of analytical legal philosophy as well as the most successful work of analytical jurisprudence ever to appear in the common law world. Nicole Lacey, in a life of H.L.A. Hart, states that concept of law remains 40 years after its publication. The main point of the reference for teaching analytical jurisprudence and along with Kelson's The Pure Theory of Law and the Journal Theory of the Law and the State, the starting point for the jurisprudential research in the analytic tradition. The concept of law was a product of Hart's initial lectures as Oxford Professor of Jurisprudence following Arthur Goodhart's retirement in 1952. Among Hart's early lectures on the law that are expanded in the book in his 1953 essay titled Definition and Theory in the Jurisprudence. Hart's discussion of Austin's legal positivism, the separation of law and morality, and the open texture of legal rules can be seen in his April 1957 presentation of the Oliver Wendell Holmes lecture at Howard Law School, titled Positivism and the Separation of Law and Morals. Positivism as an interpretive theory. Dworkin argues that positivists explain law as plain facts that have been fixed in the terms of vocabulary of judges and lawyers. He stated that theories such as those initiated by the Austin, Lon Fuller and H.L.A. Hart, which describes law, are pre-interpretive and thus suffer from the semantic stink. The central task of the legal theory is termed by the Dworkin interpretive and is partly evaluative, since it consists in identification of the principles which both best fit or cohere with the settled law and the legal practices of the legal system, and also provides the best moral justification for them, thus showing the law in the best light. So for the Dworkin, jurisprudence is the journal part of the adjudication, silent prologue to any decision at the law. In his earlier work, such as principles were designated simply as soundest theory of law. But in Law's Empire, he characterizes these principles and the particular propositions of law which follow from them as a law in an interpretive sense. Hart states that Dworkin confuses the meaning of concept with the criteria of its application. Hart disputes Dworkin's claims. The positivist legal theory, such as that presented in the concept of law, can be restated as an interpretive theory. Law's Empire, Dworkin stated that to justify the deployment of monopoly of a force, law must accept integrity as a virtue. Hart stated that his theory does not merely consist of plain facts, and he does not believe the purpose of the law is to justify coercion or obedience. His theory makes no claim to identify the point or purpose of law. Let's discuss about soft positivism. According to Hart, Dworkin wrongly states that rule of recognition mainly focuses on the pedigree of the rule as a criteria for its validity. Hart states that he recognizes that law may have more principles or substantive values that should also be considered. The concession from the Hart is labeled as the soft positivism by Dworkin. Dworkin stated that there is a deep inconsistency between those who consider morality as being the part of rules, soft positivism, and true positivists who bases validity in the process through which the law is made. Hart argues that Dworkin exaggerates the level of certainty that positivity attribute to the body of the legal standards. Hart further elaborates that the functions of the rule of recognition is to promote certainty. However, it is not necessary that a fixed criteria is needed. It is just that some criteria is essential. Every legal system should have some margin of uncertainty, which he has elaborated on in chapter 7, Concept of Law, where he gives the sociological reason for this. The underlying question then is the degree of uncertainty that can be tolerated in a legal system. Hart states that the rule of recognition would fail to promote the certainty if the test which it introduced for the law not only raise controversial issue in some cases but raises them in all or the most cases, which is Dworkin's contention that constructive interpretations occur in every case, more so in the hard cases. According to Hart, the exclusion of all uncertainty at whatever cost in other values is not a goal which he had ever envisaged for the rule of recognition. Dworkin's second criticism of Hart is his exposition that rule have an open texture and that in some circumstances the law may run out. Hart said that it is not necessary that there will always be an answer, as sometimes the law may be fundamentally incomplete. In such cases, judges must exercise discretion. Dworkin does not believe in any such discretion and rejects the idea that law may be incomplete. For Dworkin, the proposition of law is the only true when it follows from the principles which are the best fit and provide moral justification. For Dworkin, validity of the law can be based on the moral judgments. However, for him, soft positivism is inconsistent with the true positivistic picture and inconsistent with the Dworkin's understanding that positivists make objective observation of propositions of law which is independent of any consideration of morality. The social rule theory. Hart reaffirms his commitment to the social rule theory as the foundation of the legal positivism. He emphasizes that the exercise of the law depends on the social facts, specifically the acceptance of the rules by the officials of the legal system. This acceptance manifests in which Hart calls the internal point of view. Key point about the social rule theory: rules exist when they are accepted and practiced by the official. This acceptance creates normative standards. The internal point of view distinguishes rules from mere the habits. Social facts, not moral facts, determine the legal validity. Now, let's discuss the rule of recognition. Hart further elaborates on his concept of rule of recognition, addressing several misunderstandings. For example, it need not be a simple rule. It can incorporate more principle. It remains fundamentally a social rule. The practice theory of rules. Hart practice theory of law treats rule as constituted from a practice which are based on the societies, the official microcosm and not society generally. Practice and acceptance of such rules. These acts then become standards and conduct and the criticism for the individual. The external point of view of the social rule is that an observer of their practice, and the internal point of view is that the participant in such a practice who accepts the rule. There is nothing wrong if the external observers describe the practices accurately without himself being part of the system or part of the practice. He refuses Dworkin's argument that to describe the practices one must be participant in the scheme of the adjudication and adopted the view of the participant. Hart's account is defective according to the Dworkin, and he ignores the distinction between a consensus in the convention and the independent reasons for a group's recurring convergent practice of following a rule. Rules and principles. Dworkin's major criticism is that Hart fails to consider principles as the part of his theory. Hart says that Dworkin mistakenly calls law as consistingly solely of all or nothing rules. For Dworkin, Hart's theory will collapse if he adds principle to his theory, and he will have to discard his rule of recognition pedigree test, Hart concedes that overlooking principle is a defect of his book. Hart principles are broader than the rules, and the principles can justify the rules. Rule according to the Dworkin work in an all or nothing manner in the sense, and if a rule is valid and applicable at all, then it necessitates conclusively determines the legal result or outcome. Legal principles, according to the Dworkin, do not necessitate a decision but point towards a decision. Principles, according to the Dworkin, have a non-conclusive character but are valid in the law if the judge considers them relevant in inclining the decision in one way or another. Principles and the rule of recognition. Dworkin claims that as the rule of recognition cannot identify principles, it should be abandoned. He states that the legal principles can only be identified by constructive interpretation as a member of the unique set of principles, and both best fits and best justifies the whole institutional history of the settled law of the legal system. However, Hart argues that no judge has ever carried out an interpretation on the basis of the whole system. Dworkin also conceded to this as the system wide interpretation can only be carried out by his imaginary judge, Heraclius. For Dworkin, an example of the identification of the principle of the constructive interpretation can be illustrated by the Lord Atkins Neighbor principle in law and morality. For Hart, there are no conceptual connection between the content of the law and the morality, and the provisions lacking moral force may also be the rules and the principles. However, Dworkin has rejected this and stated that there must be some moral grounds on which rules are based. Dworkin states that legal rights must be understood as a species of the moral rights. For Hart, morally iniquitous law is also valid law, and he goes on to the state that Dworkin's criticism of the doctrine of the legal right and the duties may be devoid of the moral force or the justification is mistaken. Hart believes that legal rights and duties protect individual freedoms and give power to the individuals. The fact that laws are morally good or bad, just or unjust, does not matter. What matters is that such rules and laws are needed for the operation of the law. It is therefore untrue that statements of the legal rights and duties can only make sense in the real world if there is some moral ground for asserting their existence. Judicial discretion. Hart states that there are certainly unregulated cases in which no decision can be dictated by the law. Based on what Bentham said, he goes on to say that where a case is not regulated by a law, a judge must exercise his discretion and make a law for the case instead of merely applying the law which both confers and constrain his lawmaking powers, which he calls intrustial lawmaking. The exposition was rejected by the Dworkin as misleading account both of law and the judicial reasoning. He claims that law is not incomplete but the positivist picture of it, and this picture can be completed from his own interpretive theory. Dworkin states that interpretation of law, especially so in hard cases, includes dynamic derivations of implicit legal principles, which are those which best fit or cohere with the explicit law and also provides the best moral justification of it. He states that judge never has the occasion to step outside the law and exercise the law-making power in order to reach a decision. Hart defends himself by stating that lawmaking power he attaches to the court is different from the power exercised by the legislature. The judge's powers are narrower and are subject to many constraints and are only used in the particular cases. Thus, this power cannot be used to make the large scale changes in the law. Main critiques of the concept of the law. Before diving into the specifics of the postscript, we need to understand the critiques Hart faced after the publication of the concept of law. Critique by the Ronald Dworkin. Ronald Dworkin's critique of Hart's theory is perhaps the most well known. Dworkin argued that Hart's emphasis on the rule of recognition was insufficient to account for the complexity of the legal reasoning. Dworkin claimed that legal principles which guide the judicial decision making in difficult cases were just as important as the rules and could not be reduced to the application of the simple rules. In particular, Dworkin criticized Hart's model of law for being oversimplistic and for failing to consider the role of the judges in interpreting the law. Dworkin's own theory, known as the rights thesis, held that law is not just about the rules, but also involves the principles that protect individual rights, and these principles must be taken into account when judges make decisions. Hart's critiques of Austinian legal positivism. Another critique Hart addressed in his postscript was his initial critique of John Austin's legal theory. Austin had posited that the law was essentially a command issued by the sovereign backed by the threat of punishment. Hart rejected this view, arguing that Austin's theory was too simplistic and failed to account for the complexity of the modern legal system. While Austin's theory might work for the legal system with a single sovereign authority, it did not work for the systems with the multiple sources of authority and complex rules. Hart's own theory, with its distinction between primary and secondary rules, was intended to provide a more nuanced understanding of the law. Hart's response to the criticism in the postscript. In the postscript, Hart responds to the criticism that takes the opportunity to clarify and refine his position. There are several key themes and arguments in Hart's postscripts that we need to explore in details. Reaffirmation of the rule of recognition. One of the first things Hart does in his postscript is reaffirm his concept of the rule of recognition. He insisted that the rule of recognition is still central to his theory of law. The rule of recognition is a social rule that helps to identify the valid legal rules within a given society. Hart contends that the rule of recognition is not a command issued by the sovereign authority, but a shared practice among the members of the society. It is the acceptance of the rule by the officials and the citizens that gives the legal system its authority. In this way, Hart's legal positivism differs from the Austin's sovereign-based theory, as Hart sees the law as rooted in the social practices rather than commands. In his postscript, Hart acknowledges that Dworkin's critique has some merit, but maintains that rule of recognition can account for both the flexibility and the stability of the legal system. The rule of recognition does not provide a mechanical method for determining all legal outcomes, but allows for the degree of discretion, which is essential in the cases where there is ambiguity or uncertainty in the law. Hart's view of the judicial discretion. One important issue Hart addresses in the postscript is the role of the judicial discretion. Dworkin had criticized Hart for assuming that judges have too much discretion in difficult cases and that Hart's theory could not account for the judicial process properly. Hart, however, clarifies that he never claimed judges have unlimited discretion. He notes that while judges may have some discretion in difficult cases, this discretion is not arbitrary. Judicial decisions are still constrained by the existing legal rules, even if those rules are not fully determinative in every case. Hart acknowledges that judges sometimes must make decisions in the cases where the law is unclear or incomplete, but he insists that the idea of the judicial discretion should not be seen as undermining the legal system. Instead, he suggests that the ability of the judges to make a reasoned decisions within the framework of the law is a feature of the functioning legal system, not a flaw. The role of the legal principles. Another key point Hart addresses in the postscript is the role of the legal principles, particularly in the difficult cases. While Dworkin argues that principles are an essential part of the legal reasoning, Hart was initially reluctant to incorporate them into his theory. In his postscript, Hart accepts that legal principles plays a significant role in the interpretation of the law. He agrees that in some instances, legal principles may be just as important as the rules. However, Hart maintains that principles are not the same as rules. Principles, according to Hart, are open ended and provide reasons for the decisions, but they are not definitive like rules. They allow for a greater degree of interpretation and flexibility in the legal decisions making. Hart's final position on law and morality. A central issue for Hart is the relationship between law and morality. Hart's legal positivism has often been criticized for its separation of law and morality, with critics arguing that this creates morally neutral or morally indifferent legal system. In the postscript, Hart provides more nuanced view of the relationship between law and the morality. He acknowledges that law cannot be entirely separated from the morality, especially when it comes to the interpretation of the legal principles. However, Hart insists that there is no necessary connection between law and morality. He maintains that legal system can exist and function without being grounded in a particular moral theory. Hart's position in the postscript suggests that while law and morality can influence each other, they are conceptually distinct. Legal systems can operate with their own logic and rules without being subject to the moral views of the individual who create and enforce the law. In concluding remarks, Hart's postscript represented a sophisticated defense and elaboration of the legal positivism that continues to influence contemporary legal theory. His development of the soft positivism demonstrate the flexibility of the positivist theory to accommodate moral principles while maintaining its fundamental commitment to the separation thesis. The debate between Hart and Dworkin has shaped modern jurisprudential discourse, particularly regarding the nature of the legal interpretation, the role of principles in legal reasoning, and the exercise of the judicial discretion. The postscript successfully clarifies several key aspects of the Hart's theory. It establishes the rule of recognition can incorporate the moral principles without compromising positivist foundation. It defends the practice theory of the rules, which acknowledging the importance of the interpretation. It maintains the coherent position on the judicial discretion that recognize both constraint and creativity in judicial decision making. It preserves the distinction between law and morality while acknowledging their potential connection. These refinements have strengthened legal positivism's theoretical framework while providing valuable tools for understanding modern legal system. The continuing relevance of Hart's work as elaborated in the Postscript demonstrate its enduring value to the legal philosophy and the practical jurisprudence. Thank you viewers for watching this program.